Hi guys, welcome back to my channel once again. This is Batopitola. My name is Mujela Olua. You can see that I'm dressed in some way today. This is introducing to you Yashukra Onile-Okan, aka Madam Boyi Soyi. Today we want to talk about hearsay evidence. In Yoruba, hearsay means Boyi Soyi, and that's why I've tried to dress the part. Do you like it? So this is Yashukra Onile-Okan, aka Madam Boyi Soyi. That is, let's say them say, as I hear, I pass it around. So let's talk about hearsay evidence. Hearsay evidence is a statement made by a person or a party that is not called as a witness in a proceeding. So let me break it down. You'll find this provision for hearsay evidence, or the provision against hearsay evidence, in section 37 of the Evidence Act, the Nigerian Evidence Act 2011. So it says that if, for instance, now someone has made a statement outside of court, and now there's a matter before the court, and that statement is very crucial to that case, to establishing, the truth and getting to justice in that case, and you cannot bring that person to court to repeat that statement or to, say what they know about the matter as a first-hand witness, or as an eyewitness, or as the person that experienced or heard or saw, or perceived, the fact. And you have now brought someone that heard them say it, or someone that they relayed it to. When that person that you have brought, gives evidence, that evidence is called hearsay evidence, and it is not admissible. That's the law. That's the provision of the Evidence Act. But there are exceptions to it, and we're going to look at those exceptions. But before that, let me read out the Evidence Act itself, how it describes or how it explains hearsay evidence. Section 37. Hearsay means a statement, oral or written, made otherwise than by a witness in a proceeding, or contained or recorded in a book, document, or any record whatever, proof of which is not admissible under any provision of this act, which is tendered in evidence for the purpose of proving the truth of the matter stated in it. So this section has A and B. What it's saying essentially is that hearsay evidence is a statement that is being made in court by a witness that was not the direct, recipient or percipient, of the facts that the statement is seeking to prove, or statements that are made, written down, that are now being tendered in court, whereby the person who wrote them is not called as a witness. Rather, another person is coming to testify to the veracity of those written statements. So it could be oral, in that the person giving the evidence is not the person that experienced it firsthand, but it was relayed to them and they are now telling it, as second-hand evidence. Or it could be that the original person that, experienced it wrote it down, but you have not called them as a witness to come and testify to the veracity of what is written. Rather, you've called another witness to come and testify to the veracity of those facts written down. That's hearsay evidence, according to the Evidence Act. Now, the Evidence Act gives, a host of exceptions to hearsay evidence or hearsay testimony, but essentially, as much as you can, avoid it, especially in criminal matters. Let me give an example. Maybe Tola slapped Shade, and Fumi was present. So when Fumi got back to her room, she was gisting her friends A, B, and C that, oh, did you see what happened today, or did you hear? Can you imagine what happened today? Tola slapped Shade, and then A, B, and C go out, and then they go and tell others. It's spreading. By the time it gets to XYZ, trust me, it could be that they will be telling people that Tola actually shot Shade instead of Tola slapped Shade. Do you get? So that's why hearsay evidence is not admissible, because in the process of passing the information from one person to the other, there's a high likelihood of falsehood, creeping in little by little. The way that most lecturers like to explain this in class, and I think that my own lecturer did it for us when we were in school, is that they would whisper something to the first person sitting in front. So they would ask the person to whisper it to another person, whisper it to the next person, whisper it to the next person, until it goes around the class. And then they will now ask the last person that, what did you hear? So by the time they ask, people, different people, just random people, what did you hear? What did you hear? People hear different things. So maybe the lecturer had said, I ate bread this morning. By the time it passes to the next person, that person hears, I ate rice this morning. It passes, they hear, okay, you are too short. It passes, they hear, when are you going? It passes, they hear, is your name Tola? It passes, it continues to pass. And maybe the last person will only hear ate or bread. So you see that the quality of the statement, the veracity of the statement is getting reduced as it passes from one person to another. That's why hearsay evidence is suspect and not admissible in court, because there's no way to say that as it passes from one person to another, you are not importing falsehoods into it, or retelling facts the way that you please, or based on your own experiences and perceptions to life. Okay, it's just like eyewitness testimony as well. I will do another video on eyewitness testimony. I wrote an article on it about 7 years ago or thereabouts. I will leave a link to it when I do that video. It's like maybe the usual example is that someone's in-law is jumping out of the window, and you see it from your own window. You see the in-law calling out, oh, why, stop, don't jump, and then they jump, they die. And then they call you as an eyewitness from your own house, and you're saying that this person actually pushed their in-law, because you probably saw them reaching out as the person was jumping. Maybe what they were doing is that, don't jump, they were trying to pull them back, but you saw them reaching out, you saw the person drop down from the window, and then you tell the court that they actually pushed them. Now you're a sincere witness, but you're sincerely wrong, because what you saw is what you reported, but that's not really what happened. So that's just another aspect of how witness testimony is corrupted, but today we're talking about hearsay evidence. So I've explained that when information passes from A to B to C to D, it gets corrupted, and falsehood is imported into it as it passes. So that's why the court does not like and will not subscribe to hearsay evidence in most cases. That's what hearsay evidence is. Someone tells you something and you are called to witness as a witness to relay that to the court. It's hearsay because it's second hand. Or someone wrote down something and you are called to testify in that thing. You are not the person that wrote it down. So it's not your experience. It's not your fact, your set of facts. So it's hearsay evidence. So the exceptions to the hearsay evidence rule, or the rule against hearsay evidence, are, one, statements by persons who cannot be called as witnesses. For instance, someone that has died, they made a statement and they have died. That's a dying declaration. I've done a video on dying declaration. Please watch it if you have not. So you'll find a link to it in the description box. So such statements will be admissible as to the cause of the person's death, because they cannot be called as a witness. So the court will not do away with that statement just because the person is dead, in the interest of justice. So that statements by people who cannot be found, the court will employ different other means to ascertain the veracity of such statements. But because the person that made it cannot be found, they are lost, such statements will be admissible. So that's another exception to the hearsay rule. Also statements by persons who have become incapable of giving evidence, maybe someone that's comatose, or that's become invalid, or someone that has gone into insanity, for instance, someone that has become incapable of giving evidence. Statements made by them before they went into such a state can be admitted by the court despite the hearsay rule. Also, statements by persons who cannot be procured without unnecessary delay or expense by the court. For instance, if someone is out of the country, you cannot get them to come and testify as to the statement that they made. So the court will not, because of that, say it's hearsay evidence when another person is testifying based on those facts or set of statements. The court will not do away with it just because they cannot be procured into the country, based on the expense and the time it will take. But I guess that in this modern age and digital law practice era, that might be done away with, because such a person can just be linked online to give evidence. So as the law progresses, some of these exceptions are going to be done away with. The law is progressive, but these are the current exceptions under the Evidence Act. You can look at sections 37, 38, 39, going forwards. So statements by persons who cannot be procured, or whose attendance cannot be procured in court or secured in court due to unreasonable expense and delay. So such statements will also be admissible. Also, statements made in the course of business are admissible. Statements against the interest of the maker with special knowledge are also admissible. You can check section 41 of the Evidence Act. Statements of opinion as to public rights or a matter of general interest, such statements are admissible. They are not deemed hearsay. Declarations by a testator are also admissible. Also, statements as to the existence of a relationship are also admissible, despite the hearsay rule. If you check sections 46 to 53 of the Evidence Act, you'll find some other exceptions to the hearsay rule. For instance, statements by IPOs in certain cases, so that's the investigating police officers. Statements by investigating police officers in certain cases are going to be admissible. Evidence of a witness in a formal proceeding is going to be admissible in court. Statements made in special circumstances, for instance, statements made in maps, in charts, in account books, public records, statements as to facts of a public nature that are made in acts, or notifications are also admissible. Evidence of family or communal traditions, certificates of specified government officers, certificates of central bank officers, statements in public documents, and statements in res gestae. That's another topic that we're going to talk about much later. Such are statements that are admissible despite the hearsay rule. So I hope that you understand what hearsay is now. So the safe thing is, if you're in a proceeding and you need to call witnesses that have direct knowledge, perception, or experience of the facts which you want them to come and prove. Okay? Call eyewitnesses, call ear witnesses, call perception witnesses, people who saw, who felt, who perceived, who heard what you want them to come and prove in court. And if someone has made a statement to the police or otherwise, call them, let them come and testify on their own statements instead of calling a third party. Even in real life, but you saw hearsay, second-hand evidence, second-hand information is always suspect because there's a presumption of falsehood. So that is hearsay evidence. I will see you in my very next video. To-dos. So, Mr. Yashukura Onile Okon, I hope that you listen to Ola explain what hearsay evidence means, which is boy you saw in Yoruba. So please keep listening to Ola and keep watching Bat Up with Ola till the need arises again. Yashukura is saying bye.